Ladies and gentlemen, thank you very much for coming back roughly on time. There'll be more coming through the door in a moment, but we better get cracking. The next session is our session on market regulation and competition, chaired by Fergus Randolph QC, who sits gloriously in the middle of an extremely eminent panel. I'll let him introduce his panel and his session. Please don't consider these sessions as self-standing, but look to see what themes and links might flow over from one session to another. One thought that I have is to what extent human rights law as a tool of business improvement in business practices, can be developed. And in that context, I'll be very interested to see what market regulation has to say in that regard. Fergus, over to you.
Thank you. Thank you. Is that on? Is that on? Yep. Thank you, Harry. And I note your question, and I'm sure our panelists will seek to answer it. Good morning, or good late morning. Welcome to this session on market regulation and competition. My name's Fergus Randolph. I'm a barrister at Brickcourt Chambers, and I'm delighted to be chairing this session on market regulation and competition with you this morning. I noted that Harry mentioned Los Galacticos. Well, I think we'll do something slightly better than that. We're going to go for the World Cup, Rugby World Cup, which is presently being hosted by England, and my panel is a wonderful is a wonderful example of that, and I'll go for South Africa and the Springboks. Yesterday, I flew back from Hong Kong, where I'd had the immense privilege to attend a seminar, amongst other things, on the rule of law, addressed by the Chief Justice of Hong Kong, Geoffrey Ma, and Lord Judge, previous Lord Chief Justice in this jurisdiction. What was very clear from the presentations was the unanimous acceptance of the importance attached to the rule of law and its full implementation. In recent days in Hong Kong, and I don't know whether this has come across here, but in recent days there have been unfortunate comments from certain quarters suggesting that certain posts within the executive were above the rule of law. That, unsurprisingly, was not a position accepted by those who spoke at the seminar. As with Hong Kong, to a certain extent, so with Africa, the rule of law, I would respectfully submit, is critical to the continued development of Africa and its markets. Our panelists this morning, all distinguished experts in their field, will be touching on that directly or indirectly in their talks. In terms of running order, we will start with a presentation from José Costa Pereira, who, as you can see from your program, is the advisor in policy and communication in the Africa department in the European External Action Service, essentially the EU's foreign office. We're then going to move to Alastair Sutton, then Jeremy Gauntlett, and finally, last but not least, Robert O'Donoghue. In terms of their experience, their biographies are set out in the conference pack, but I would just like you to know a little bit about each of the speakers. José is a Portuguese diplomat currently working, as I say, in the External Action Service, and he was former head of the Task Force Africa in the General Secretariat of the Council of the European Union. So he comes at this from an institutional perspective, and I'm looking forward very much to his talk from that viewpoint. Alastair is somewhere between institution and private practice. He spent a long and distinguished part of his working life in the institutions, in the Commission, particularly working in Lord Cofield's cabinet, and really was there as a key part of the operation in getting the internal market up and running. And his talk will be touching on the internal market and what lessons Africa can learn from that internal market policy. Alastair then left the Commission and has worked for a number of years equally distinguished, in an equally distinguished fashion in private practice. Then we have Jeremy Gauntlett, senior counsel who has wonderful experience in the courts in Africa, including in South Africa, and he will be giving his unique viewpoint as to certain aspects of the rule of law, and in particular how merger activity and the rule of law has operated within South Africa. And finally, we have Robert O'Donoghue, who is a member of Chambers, as well as Jeremy and Alastair, who will be essentially touching on competition law and the approach of South African courts to competition law, and more generally, due process in administrative proceedings. So with that, I would ask José to start. We're going to try to keep each of the presentations to 10 minutes. That will allow, I hope, for full audience participation after the presentations, and indeed to have some form of debate, I hope, between the individual participants on this panel. Thank you very much indeed, José.
Thank you, Fergus. Good morning, everybody. You know, while I was sitting here, I was asking myself, am I at the right place? Having in mind that I'm the only non-native speaker on this panel, and probably amongst all of the audience in first place, that I have no legal background and I'm supposed to speak about rule of law. And thirdly, that I'm not even an academic, the ones that Harry said at the beginning should be sent to the shark pond, but just a bureaucrat, a Eurocrat, and I'm in the UK. And I must say that Fergus' reference to rugby instead of soccer did make my life easier for sure. Now, oh, on top of everything else, I forgot my glasses, so I can't even see you. Now,
This is going very well.
now, seriously, I like challenges, and certainly this is a challenge, but I'm trying to convince you of two things. First of all, that it's fundamental that rule of law would be at the center of European Union policy vis-à-vis Africa, and secondly, that the Africans are moving precisely on that direction. Now, why am I saying that? We have to look at the basics. Nowadays, 14% of the world population lives in Africa. In 2050, which is a date that is now as a symbolism, there will be 40%. Now, this makes it very hard to find jobs for all this young population, the one that is already there and the one that is coming. But it's a fundamental issue for the Africans, and I would dare to say, not only for the Africans. To do that, it's necessary to have investment. Not only the traditional investment by the state sector that has been paramount in Africa for decades, but also investment by the private sector. And in order to make it sufficiently attractive for the private sector to invest, rather, you need to have a level playing field. You need to have transparency. You need to have accountancy. You need to have justice that is working. Because if you go there and you invest, you need to know that your capital is safe. You need to know that in your relationship with a whole gamut of people around you, suppliers, consumers, workers, the state itself, there will be someone to mediate the conflicts that might arise here and then. Because if you don't, you won't invest. So there is need to attract this investment, and either international or local. There is need to lower barriers, non-tariff barriers, tariff barriers. There's need to look at the fiscal universe in Africa. And it is important for us, European Union, to support that effort. Why? Well, first of all, because of our values. Our values are values that are encroached in the respect for the rule of law, in solidarity, in democracy, in respect for human rights. So in the principles, like any other soft power, we try to project our principles all over the world. Secondly, we have an interest, commercial interest, of course, because if we can invest, if our companies can be competitive, we are also helping our own job market here, and we are helping Africa at the same time. So it's a win-win situation. Thirdly, another interest, which has to do with the situation in Europe. Now, you probably read the papers. There is something like 9,000 people coming Europe every day in Croatia. Now, can you imagine if nothing is done, if those jobs are not created, when we go from 14 to 40%, I'm sorry to say, but 9,000 people a day is peanuts. There'll be much more. You can multiply this by 20, 50 times. Can Europe absorb all these people? But I'm sure they will come, because hope is the last thing to disappear. If people don't have stability, if people are victims of misery, war, terrorism, if they don't have any kind of possible outlet to express their feelings, they will move. And they will move where? Where wealth is perceived to be. They will move here. They will not move to China. They will move here. Or they will not move to the United States because it's easier to get here. And can we absorb them? I very much doubt it that we can. So it's in our interest to support Africa in order that Africa creates those jobs. It's in our interest to create the conditions that would allow Africa to create those jobs. And that's why we invest so much in peace and stability. That's why we invest so much in rule of law. That's why our tools, our development tools, are based in this idea that we have to build a different Africa, or contribute, rather, to build a different Africa. What we do in world terms, it's unique. Our European Development Fund is something in the area of 30 billion euros, which I don't know, in the current rate would be what, 42, 45 billion pounds. This dwarfs any other contribution to Africa made by any other country. Just to give you an example, because I think it makes it easier. The other day, the Chinese signed with the African Union some document saying that China is going to provide a one-off 5 million grant for peace and stability activities within Africa. Do you know how much Costa has AMISOM? You know the African Union mission in Somalia that is trying to prevent a fragile state to collapse? Well, it costs us 20 million a month. It costs you, because you're the taxpayers. So this gives you an idea about size, about dimension of the support that the European Union does and the others don't, at least. Not that we wouldn't welcome them. More than sharing should be the catchphrase here. Now, from the African point of view, for many years, there was a recipe based on Cold War, based on strong leaders. You will remember the Kahundas, the Jerry Rawlings, the Kenyatta's father, and their idea that the state should be socialist, that the state will bring prosperity to their citizens. It didn't work out. So now we have a different kind of politicians in Africa that are keen to see private investment come to support the possibility of creating those jobs. It's a process, and it's not equal in all parts of Africa. We tend to see Africa as one single entity, and it's not. It's a lot of differences within African countries. But these people are looking at it from a different perspective. We saw it today when we had this particularly interesting talk by Eva Thorne about Liberia, how they are changing in a way that it makes it more transparent, more accountable. We'll see what Alastair is going to tell us afterwards, with all the caveats. She spoke about some caveats, he's going to speak about some caveats for sure. But this is the trend, and that's the trend that we have to support. That was, they agreed in 2014 when we have the EU-Africa summit in Brussels. This was part of the declaration at the end. The need to respect the rule of law and the understanding that rule of law would be the basic tenet that would allow for this peace and this prosperity. Now, of course, this is going to be a long road. African time, perhaps. But it will get there. They will get there. Africans will get there, because this is fundamental for them. Otherwise, it will be chaotic. I know some of you are certainly thinking about that. What's it talking about? We're still problems in Sudan, problems in Mali, problems in Somalia, problems in the Central African Republic, in Democratic Republic of Congo. Yes, indeed, they are. And that's a problem, it's problems that we need to solve. But the difference is fundamental if we compare what happened 20 or 30 years ago. Look at Burkina Faso. You know, I suppose the British press spoke about it, I hope so. They got a putsch, a military putsch. Now, if that did happen 30 odd years ago, this gentleman would still be there, and would be there for the next 5, 6, or 10 years. 1 week later, they were out. Why? Because there is international pressure, because there is strong African pressure, peer pressure, and because Africans themselves, the civil society in Africa, does not accept anymore as a recipe that they need strong men to lead their countries. So we have an involvement, a progressive involvement of the populations and even of the leadership into a democratic process. And I was very, very, very much satisfied by the fact that we have elections this year in Nigeria where the incumbent lost and allowed for his replacement to take the presidential palace, his post in the presidential palace, without any problem. And this is a fundamental thing when the person that loses the elections in an African election stops being the loser and becomes the leader of the opposition. And this is something that is already happening in Nigeria, to a certain point in Ghana, Zambia too, but it's not yet completely overall in African leaders' mentality. But again, this is the trend. So the trend would be probably that in the future we'll have some African countries that will be prosperous, some African countries that will be in the first row, and we might have some other countries that will be not able to keep the same level of, same rhythm, if you like, because they have not yet understand the need to let their populations have a way to express their feelings, their frustrations, their opposition. And this is one of the things that is driving Africa backwards. The inability sometimes to understand that only through the democratic process you have the possibility to actually have another option, and that's the democratic game. So, all in all, I'm ready to the 10 minutes. I'm not sure I have a climax now at the end of the 10 minutes after the initial earthquake, but this idea is this is the future, this is the road, and the European Union is in this partnership with Africa, and the European Union member states are all, I would say, in the same room, pushing for the ability for rule of law to define the nature of our cooperation with Africa and the good results that can come out of it. Thank you very much.
Thank you, José. Alastair.
Thanks very much, Fergus. And José, yesterday morning I had no voice at all. If I had a voice, I was going to call Fergus and say, I'm not sure I can speak this morning, but the consolation is that having half a voice, I will certainly stick to my 10-minute limit. Anyway, that's the good news. What Fergus didn't mention was that for the last 4 years since retiring, that's a relative term in inverted commas, I've been going to Africa on behalf of the European Commission, trying to, should we say, explain what are the elements of the single market policy which has worked so well in Europe, which might be of interest and benefit to economic liberalization and integration in Africa. And in that context, I went first to Addis Ababa because it's the head of the African Union, which, as we've heard, has now got 54 or perhaps 55 very diverse, heterogeneous states. That was very interesting. It was a good start, but it was, let's say, a very difficult process at the continental level to promote these ideas. I then went on a series of visits to Lusaka to speak to COMESA, to Arusha, to the East African community, to Ouagadougou to speak to the Union économique et monétaire West Africain, to Dakar to speak to UMOA and ECOWAS, the Anglophone West African Economic Community. And most interestingly of all, to Swaziland, where the COMESA Court of Justice, 12 judges representing 19 member states from Egypt to South Africa, held a seminar, 2-day seminar on the rule of law, but more especially international economic law, how to promote trade liberalization and integration in the COMESA area. Before I go on to the African experience, I want to really say, in a nutshell, if I can, what it is about Europe that has been, shall we say, inspirational over the last 70 years. Because for the last 70 years, the rule of law, the rule and the role of law, not just the rule of law, the role of law and lawyers, has been a major factor, as we all know, in economic policy generally and the liberalization of trade and investment in Europe. Competition law and policy, about which we hear rather little in Africa, both at national and European levels, including state aids controls, has been an increasing force for liberalization. And we've seen that over the last 10 years with the European Commission increasing its investigative and punitive activities in competition law. Access to justice and dispute settlement for economic operators and states has been absolutely crucial in Europe. The fact that the three fundamental principles of European law, direct effect, supremacy, and the availability of remedies against states, are made by judges, have been made by judges in the 1960s, is absolutely, I think, illustrative of this. International economic law, the GATT, the WTO, has played an important role, obviously, in the last 70 years, since 1947, in liberalizing trade in goods. Most probably African states are now formally parties to the GATT, to the as I call it, the WTO. In my view, this has not been a great success. Problem of resources, representation in Geneva, a tendency to go the UNCTAD route rather than the WTO route. But in any event, for us in Europe, the GATT was the inspiration for the EEC in 1957. We must never forget that. So the EU's progress over 65 years from free trade area, effectively, because we didn't have a customs union in 1957, to customs union in 1968, single market in 1992, embryonic, not perfect, but abolition of national frontiers in 92. Economic and monetary union, again, according to a set timetable, by 1999, formally, the euro in your pocket in 2002. Obviously, this has been an enormously successful post-war evolution in Europe. And as I say, the fact that progress of economic liberalization and integration has been accompanied by consumer protection, health protection, environmental protection, social justice, social welfare models, cooperation in criminal justice, civil justice, and so on. All that has been noticed around the world. And certainly in Africa, as José just said, the EU and Africa and the African Union have agreed that this is a model to be emulated, with caveats, as you say, and with regional differences and so on. So what are the key factors which have been responsible for the success, relative, but certainly a success in Europe? I'll be very quick. First, the clear need in 1945 for a new start, obviously. After two devastating world wars in 30-odd years, we wanted to have a new start. We had that. The existence of strong legal traditions in all the member states, and particularly, and slightly ironically, in this country, ironically because of the current debate in this country about the future of our relationship with Europe. But anyway, but the strong legal traditions were obviously very important in the European Convention on Human Rights, but also in the EU. The creation of supranational institutions, absolutely vital in my view, especially the Court of Justice and the Commission. But the Court of Justice, supranational, not classical international. The development of a strong esprit de corps amongst European civil servants and judges, facilitated by the willingness of member states to go along with this. When I'm saying these things, I'm thinking Africa. How, to what extent are these concepts, these, elements are exportable? The fact that Europe, since 1968, 11 years after the treaty was signed in 57, have had a single voice in the GATT under Article 113 of the treaty. Visible, tangible, measurable economic success, despite periodic setbacks, for example, the recessions in the 1970s, with broad-based public support. I know that sounds funny now, but broadly speaking, the European economic integration has benefited from that tremendous support, and still does so today, actually, from European business. And finally, and for me, I've said this very often in Africa, a system of close administrative cooperation, building mutual knowledge, trust, confidence, respect, and I'm going to say friendships amongst stakeholders. José knows exactly what I'm talking about here. Especially national civil servants, I would call it, and it's very dangerous to say this in London, but the Brussels Club. 28 national representative civil servants coming together to talk about value-added tax, customs, health protection, environment, and so on. And so despite all the undoubted strains which have, come on the scene in the last 10 or 15 years, flowing from the absence of consolidation, we've had 7 enlargements of the EU in the last 20 years, 30 years. We've had 5 constitutional conferences. We've got the unresolved 2008 economic crisis, and as José says, we've got the migration refugee crisis, which is a massive issue. It's the biggest threat to the continuation of the European project that I've seen in 42 years in Brussels. Right, that's the European side. What's my take on the African experience in this area, economic liberalization and integration? Number one, it's rubbed in every time I'm in Lusaka, Dakar, Ouagadougou. The relatively recent independence and lack of political willingness to cede or pool sovereignty other than in classical international organizations. 2, frankly, a lack of experience amongst civil servants in work on economic liberalization and integration. For example, how many African civil servants have worked in the GATT on tariff policy and non-tariff policy, to take the real basics of trade liberalization? Relatively few. Many more from South America. Many more, of course, from Asia, but not Africa. Africa is the poor relation of the WTO. Lack of political stability, both within artificially created post-colonial states and regionally, lack of political stability. Until recently, a focus on classical aid rather than trade or technical assistance. Genuine cooperation and technical assistance. José mentioned the enormous sums we give in classical development aid, both at the EU and national level. But what about getting more involved in Africa through technical assistance, legal assistance, economic expertise, swapping officials, between European and African states? It happens, but it doesn't happen enough. The sheer size of Africa, 54 states. This is why I don't go to Addis Ababa anymore. I go to the RECs, to the Regional Economic Commissions. The other thing is what I call the lasagna effect. Africans, like many, they don't have any monopoly on this. They love making treaties. And at the great risk to my personal safety, probably, when I've spoken in Addis Ababa in the United Nations Hall there, I said, you're just like us in Europe. You love flying around and going to hotels and drinking champagne and signing things. But when it comes actually to enforcing them, you're not so great. And by the way, neither are we. We've come a long way, but we've got a long way to go. And the number of, we now have a continental free trade area which was negotiated last year or is still being negotiated. There's another layer of the lasagna. So lots of law, not much enforcement. Lack of credibility because lack of enforcement. So weak enforcement, diminishing credibility in the system, and lack of imagination at the level of the RECs, the regional economic communities, to devise innovative dispute resolution systems like we've developed in Europe now: peer review, soft law, conciliation, mediation, institutional means of involving stakeholders from the very beginning in rulemaking and actually in enforcing the law. Law enforcement is seen very much as a win-lose situation in Africa. And one thing I've tried to get across, I remember my discussions with the Zimbabwean Secretary General of COMESA, a very dynamic and brilliant man. Why don't you use your dynamism and brilliance with your member states to promote dispute resolution across frontiers on a peer review basis? It doesn't need to be that the COMESA Secretariat in Lusaka is making war on the member states. We forgot that a long time ago in Brussels, although perhaps President Juncker is bringing it back. But, you know, I've taken Germany to court on their beer restrictions. That was a very brave thing to do when you attack Germany on restricting imports of Stella Artois. But the Court of Justice, in the end, found against Germany, and trade in beer is now liberalised. But we always start in Brussels with discussions, technical discussions, because we see that dispute resolution is very often in the mutual interest of the disputants, and it's not just a win-lose situation. I know I've got to stop, so I'll just read out the following headings and stop at that point. See, my voice lasted longer than you thought. So, now, we in Africa talk always about, it seems to be, about trade in goods. And somebody said in the previous panel, that the possibility of digital services, telecom services, transport infrastructure services, these must not be forgotten. And there is an opportunity to do in Africa what we have not done in Europe, which is to leapfrog straight into liberalization of telecom services, digital market services, and so on. Cherry picking the good bits of European law, making it simple, making it clear, making it enforceable in those high value added areas. Liberalizing investments, we heard a lot about that today, and that's great. The need, we can't miss it, the need to address corruption is absolutely crucial because it diminishes credibility in the system. And of course, the only way that can be done is internally. So all the remedies in Africa have to come from the inside. What can Europe do? Well, we can impose conditionality and all that stuff. But we have to be there, we have to be on the ground, we have to lead by example. The same Zimbabwean Secretary General of COMESA said to me, you know, we love you much more than the Chinese, but you've got a huge post-colonial hang-up. You're afraid to come down here and give your messages the way you're doing. And I said, well, I have no problem about doing that. He said, because the Chinese are not doing that with us, but we need your experience and your expertise in this way. And José, I don't think that Europe, with all its changes since the Lisbon Treaty, I don't think we've got our act together in Africa. We haven't realized the crucial importance, as he so eloquently said at the end of his remarks there. If we don't solve this problem now, it'll be infinitely worse in 20 or 30 years' time. Final thing, I think African civil servants in the Rex could do what we did here in 1986, the cost of non-Africa. Do some studies on what the costs of the current barriers, including corruption, the need to pay all these bribes and so on. What is the cost to economic growth in Africa of the cost of non-Africa? Use timetables and action plans with political accountability more. And above all, as I say, the solutions have to come from within Africa with good politically motivated African leaders. Thank you very much.
Thank you. Thank you very much indeed, Alastair. A lot of interesting points raised there, which I hope will be discussed after the formal presentations. I'm now going to hand over to Jeremy. One thing I didn't tell you about, and I'm sure he won't because he's far too modest, is that he has got almost unparalleled experience in the various courts in Southern Africa. He's been leading counsel in the Constitutional Court, the Supreme Court of Appeal, and the Competition Appeal Court, and the Labour Appeal Court of South Africa. So that's pretty much all the courts. And he has been in the High Courts and Supreme Courts of other South African countries. So who better to take this debate forward but Jeremy?
Thank you, Fergus. Market regulation and competition in Africa. May I bring us down to earth with a bump? May I do so through what might seem to be modest, but is immodest because it concerns a single case. So it seems a vaulting ambition to try and pull together some of the themes we've picked up in earlier sessions and through earlier speakers, and to bring home to all of us, those of us who practice as legal artisans, those who operate at a higher level as risk managers and investment companies, but some of the current regulatory constraints that you will experience in certain African countries. immediately the single example has to be the largest merger which has actually happened in sub-Saharan Africa, certainly. And that is the Walmart Massmart retail merger. That manages in one go to sweep up 5 countries, which does help to take us out of a single country box, to pick up on certain themes. I need, in speaking about it, to make the disclosure, which embarrassed my children very much when they were smaller, as to the names of my clients. And in this instance, it was Walmart. They are now much older and equally horrified that my clients include not so much the Treasury, but the President of South Africa in resisting the al-Bashir warrants and people of that ilk. One does point out, of course, to one's children that certain compensations do follow from the fact that one does have a clientele. Now, in the swath of African countries in which Walmart sought to push through this merger, you had what is perhaps a fairly representative position. Highly active and sophisticated competition authorities in South Africa, newer but functioning and growing fast in Namibia, and elsewhere in the Southern African region, actually rather tentative and therefore timorous, new institutions incorporated in governmental bodies, the usual departments of trade and industry. And onto the scene then lumbered this behemoth, Walmart, which I was told when we first consulted was the second largest employer in the world. So I asked naturally, what is the largest? And the answer was the Chinese army. Well, I'm not sure that the members of it consider themselves employees, but that's by the by. The critical thing was that Walmart had to get through the usual hoops in relation to the merger that you would expect as a competition jurisprudence has worked itself out through Commonwealth countries. Firstly, the important question is, would there be a substantial prevention or lessening of competition? Secondly, if there was going to be such, was there an identifiable, cognizable efficiency, technological, or other balancing pro-competitive benefit? But lurking in these countries was a consideration which goes to the heart of much of what we heard this morning, and I believe will spread wider in some of the aspects being discussed. And it is this: it is a recourse to a factor as to whether it would be in the public interest. And for all of us, all those of us who have had to seek to enforce ICSID and other awards in Africa will know that there is that substantial concern that courts will rise up at times through a form of resistance to internationalism and assert sovereignty. It's a reality which I believe has to be grasped, has to be understood. And part of it, as you heard earlier today from Emily, relating, for example, to the South African backlash on bilateral treaties, is the feeling that they've been taken to the cleaners. They've been exploited at an earlier time. They have, as Alastair was saying, perhaps in the way that governments do in a flurry of activities, signed up to too many things at one time, which is South Africa's dilemma with al-Bashir and its own immunities legislation. And there is this very, very sensitive aspect which I believe all of us who work in Africa need to deal with, which is an understanding that it's not a form of chauvinism or xenophobia, but it is a concern that actually they've got hold of the short end of the stick, and how are they to negotiate in those circumstances. Now, to take the Walmart situation, it was easy, you would think, on a first-level competition overview. Walmart had no pre-merger presence at all in Africa, so there could be no substantial lessening of competition attributable to merger itself. The real and so one didn't even need to engage the balancing factor as to whether there would be technological or efficiency gains. And such is the worldwide empire of Walmart that it is very easy to demonstrate huge efficiency gains through particularly its supply chain control mechanisms. But up rose the specter, the third factor, I think T.S. Eliot writes about the third tempter, and that is this presence of public interest. And in both Namibia and South Africa, governmental ministries intervened in the proceedings to say Walmart has an atrocious employment record. Secondly, it will smash local procurement. And for these considerations, never mind what it does for the consumer, what it will do for employees or do to employees, and what it will do to the economy will, in the greater scheme of things, be catastrophic. In the end, to cut a long story short, it played out rather interestingly through figures. The projection had been that a 1% change in procurement from domestic producers to particularly the much feared idea of the Walmart resort always to China would result in a loss for every 1% of 4,000 jobs, which in the Southern African economy means on average a minimum of 10 dependents per job. So you look at a very substantial ripple effect. On a projection of 5% or to 10%, you're looking at 40,000 jobs, 500,000 people would be affected. The counterfactual, however, and this is the problem that we all have to deal with in competition at times, was that what was also projected was a 5% reduction in prices on current turnover, which in rand terms would be a 2.5 billion windfall, if you like, for consumers. And because Walmart is pegged at the level, not of Waitrose, and I won't get into libel problems by mentioning other enterprises, but it is directly money into the pockets of some of the poorest consumers. Ultimately, what happened? Each of the regulators in these countries approved the merger. The ministers and the South African trade unions, which are very powerful, fought to the end on the jobs issue and procured certain conditions which were very much on offer anyway, that there would be no merger-specific retrenchments. But on the crucial factor they were Walmart could win through was to show that it would obtain 90% of its procurement needs domestically, and in terms of foodstuffs, 99%, which of course makes sense. You're not going to import an orange from China for several reasons. So the critical aspect at the end in the merger as it played out across these countries were these factors. First of all, the acceptance that government was trying to use competition and market mechanisms actually to achieve a very laudable social objective, but one which was not permitted in terms of the respective competition acts, and that is a maximization of employment. It was leverage being used in terms of the transaction. It's hugely problematical because it's an understandable political goal of any government to seek to do it. But it had to be fought off, and it was successfully fought off. And in fact, the South African Competition Appeal Court had harsh things to say about the intervention of the South African Minister of Economic Development to seek to achieve that. Secondly, the regulatory inquiry as to the public interest is not, as those on the statist side would like to have it free-floating. It takes place in a competition environment, a competition context. You may very much wish to see the end of Volkswagen's emissions, truthful or otherwise, but you cannot, through a competition regulation mechanism, seek to pursue an environmental object. Environmental authorities must pursue that through their own legislative framework, and government cannot, as it were, rummage desperately around the statutory landscape to find those particular levers. That was borne out also in the regulatory agencies in this particular instance. But lastly, what is also clear is that public interest provisions in market regulatory statutes, certainly in Southern Africa, are not to be underestimated, nor is to be underestimated the determination of government not merely to kowtow before foreign investment. For many free marketeers, this is a maddening proposition, given the depth of poverty and the need for economies to expand. But certainly, the days of going into Africa equipped with a copy of the Competition Act and a pith helmet are over. Thank you.
Thank you very much indeed, Jeremy. Robert?
Thank you. I'm going to talk for 10 minutes about some due process issues in general terms in the sphere of economic regulation. I'm struck by the fact that there's a risk in pontificating and evangelizing about due process, that one ends up with what I would call the Cecil the Lion syndrome. Now, during the silly season this summer, there was a huge storm in a teacup about the killing of a lion in, I believe, Zimbabwe. And it had all the makings of a great Hollywood movie. This was a particularly kind, dangerous wild animal known to all and sundry in Zimbabwe. There was an American villain who liked killing things, and it all ended very badly, particularly for the lion. And there was huge emoting from social media lecturing Zimbabweans and other Africans on what they should and shouldn't be doing. And there's a journalist in this country, Simon Jenkins, who's sensible, and he said, can you imagine what would happen if wealthy Africans came to the United Kingdom and said, for example, that the way you've been treating the red squirrel is a disgrace, and the way you've allowed the grey squirrel to effectively eliminate them is a national disgrace, and something should be done. So there is a risk with due process across 54 different states, each of which with different features, that we end up with the Cecil the Lion emoting syndrome. But I'm going to try and avoid that, and hopefully we can have at least a common denominator. Now, in my defense, I would say two things. First of all, it's taken us about 700 years to get to this point, so there's an organic element to this process. Now, the second thing is that there is not a very clear and universal consensus, even within Europe, as to what due process in the context of administrative proceedings and appellate litigation means. And here are some papers which expose some of the divergence, or at least lack of universal agreement on these issues. Now, in your pack, you have a very long and detailed and in parts boring article from my colleague Tim Johnson and I, where we set all this out in nauseating detail. Now, what I'm trying to do for the next 6 minutes is give you our greatest hits. Now, what I've done is extract what I would regard as non-negotiable aspects of due process, particularly in the context of economic regulation and decision-making, then some nice-to-haves, then some very nice-to-haves, and then finishing up with how to balance confidentiality and rights of defense. So in terms of the 6, in my humble opinion, non-negotiables, the first is obviously the guaranteed independence of the decision-maker, and that obviously means freedom from outside brackets political interference, but also, and I think as importantly, the resources and personnel to do their job and take effective decisions, because there isn't much point having independent one man and his dog economic regulation office if they're entirely dependent on a complete lack of resources. So that's the first one. The second, again, this is blindingly obvious to most of you in this room. You have the right to know the case against you. The agency cannot rely on evidence which has not been put to you. That is one of the most basic axioms of due process. Following from that, of course, there's the right to see the evidence, both inculpatory and exculpatory, and more importantly, to challenge it. There is the right to be heard by the actual decision maker, rather than some proxy or some non-decision maker. There is the right to a reasoned decision within a reasonable period of time. On that note, a client of mine, Google, they've been engaged for more than 5 years with the European Commission in relation to various search complaints. The same case in Russia, from start to finish, took 2 to 3 months. Now, I would love to tell you all this is a wonderful advertisement for the efficiency of Russian antitrust law, but I'm assured that that is not an entirely fair characterization. So it should be a reasonable period, but also not unreasonably short at the same time. And there is, of course, the right to an appeal of the decision before an independent, competent court. Now, this is all common sense and obvious to everyone in this room, I think. But the reason I think that it is of interest to start thinking about these problems, I mean, as you have international corporate clients who increasingly will be doing business in Africa, in liberalized or liberalizing markets, I would suggest that this sort of emerging consensus is quasi-global, and that these sorts of ideas that seem obvious and basic are ones that will increasingly, I hope, get traction, or put another way, will be increasingly difficult for decision makers and courts to ignore. So this is an organic process which, as I said, has taken 700 years in this country. It remains ongoing. But I think these are fundamental principles and tools that you can use with your clients and with local counsel in interacting with local decision makers. Things that are, in my view, nice, are very nice to have, perhaps not as essential. First of all, a proper separation between the investigative teams and decision makers. This is the judge and jury problem. Again, in Europe, we have not quite cracked this particular problem because we have a European Commission, for example, that is effectively judge and jury, subject to various devil's advocate panels and one or two other soft safeguards. There should, of course, be a transparent decision-making process. Again, blindingly obvious, but there should be records of key meetings. The notes of those meetings should be transmitted to defendants. They should be available on the file or to other affected parties as a matter of course. There should, in my view, be a proper adversarial hearing before the actual decision maker. Again, in Europe, we have not entirely cracked that one either. We have an oral hearing in Brussels before the European Commission that is, I think, a form of window dressing, at worst or at best a form of light entertainment. You should, of course, know the case against you in full, and you should be able to test the evidence against you properly. I mean, again, coming from an adversarial background, there seems no reason to me why decision makers should be afraid of hearing live evidence where that is necessary and useful. Fifth, informality in lobbying should, in my view, be generally deprecated. Things in Europe on that front have improved. A lot of business in Brussels used to be done over tennis courts and lunch. I think those days are dwindling. And a few final points before I wrap up for questions. On the subject of appeals, this is potentially very, very complex because there are many, many forms of appeals, judicial review, merits appeals. But in general, in the sphere of economic regulation, I would suggest that what we are looking at is an appeal typically on the merits. I mean, that is not universal. In this country, for example, merger decisions are subject to judicial review. But in general, in the sphere of economic regulation, given the implications for the stakeholders, I think there should be something akin to an appeal on the merits, and the court should have full jurisdiction. Now, that will vary from context to context, but I think it means a review on the merits that extends to the review of the evidence, to findings of fact, law, and the penalty if there is one. Importantly, the capacity to substitute findings of the authority in question with the court's own determinations. Of course, that is not a full rehearing, but nor at the other extreme, in my view, should there be a presumption that because the authority has said something vaguely falling within its sphere, that must necessarily be correct. There must be some scope to challenge that. There should, of course, be the opportunity to make full and detailed submissions by way of defence. And again, picking up on a point I mentioned in the context of administrative proceedings, the court should be able and willing, on occasion, to call for live evidence on particular issues, and to make its own determinations on the facts. A couple of final points quickly on the question of confidentiality. I've had cases outside of Europe recently, not in Africa, I might add, where the authority in question said to us, well, the evidence submitted by your direct rival and complainant, we can't show that to you because it's confidential. And so these apparent conflicts between rights of defense and confidentiality come up again and again. But I would suggest in 99 cases out of 100, they're entirely solvable on the following sliding scale. The authority can, of course, make the defendant aware of the gist of the point against it. The extent to which there is detail in the gist will depend on the importance of the issue and the level of the confidentiality concerns. Second, a very common practice in litigation and administrative proceedings is the creation of confidentiality clubs. Again, there's a sliding scale in terms of how they can be crafted. The strictest ones limited to external advisors or counsel, sometimes admission of in-house counsel, and occasionally the admission of business people, depending on the sensitivity. And finally, we have a lot of experience in the context of administrative decision-making in the creation of data rooms, where you can access the hypersensitive information, at least in physical or virtual form, perhaps not take notes and remove the documents themselves, but there is at least the possibility to access it. I want to pick up on a few things Jeremy said, but I'll hand back to Fergus first of all.
Thank you very much indeed, and thank you all panelists for keeping to time. I think, looking at Harry here, we should, 4 minutes? 4 minutes. I was hoping we could get to 12:30, because if I wanted, anyway. Sanctions, I appreciate that, but we did start late. Anyway. We'll see. Ladies and gentlemen, can we have some questions, please? Right, while you're thinking of your questions, Robert, do you have any questions for, you said you had something for Jeremy?
Well, I mean, just put a few things in the mix. I mean, Jeremy's speech was extremely interesting to me. My own more limited experience of dealing with competition and regulatory cases in Africa, I mean, there were a few things I jotted down. Now, the first thing, which to a certain extent goes in the other direction to what Jeremy said, is that there is evidence of huge amounts of sophistication in terms of, particularly the South African competition courts dealing with competition and regulatory cases. There are two cases in particular, Mittal and Sasol, on excessive pricing, where the level of sophistication, particularly in economic terms, would make people in the Competition Appeal Tribunal a bit red in the face. So that's sort of a positive thing. The second thing, which I think is, well, maybe positive or maybe negative, depending on your perspective, is the South African courts, particularly in these two cases, were extremely open, in contrast to, say, US courts, to looking at European law as a source of potential inspiration. Again, there is a debate as to whether using foreign law is a good thing or a bad thing in terms of indirect influence, but there you have it. I would strongly echo what Jeremy said in terms of what I would call a complete confusion of trying to mix competition and consumer welfare objectives with social objectives or other public interest factors. I mean, in a nutshell, what has happened in this country and in Europe is that the ability to hijack competition cases with public interest or other concerns is paper thin nowadays, essentially defense and media cases, and even then eyebrows will be raised. And I mean, the confusion of trying to mix up total welfare, consumer welfare, with social objectives and non-competition objectives, I mean, it's a complete disaster, and these things are completely intractable, and the idea of trading them off against each other is utterly pointless, because it is apples and oranges. And finally, on the question of leverage, which Jeremy mentioned, I mean, a feature we see in particular in merger control is that merger remedies are being used on occasion as ways to secure leverage for local economic / political / social objectives. Now, again, may or may not be a good thing, but it is a feature that your clients need to be aware of.
Thank you. Jeremy, do you have any thoughts on that? Or? No, good, excellent. Alastair has got something to add, I think. And ladies and gentlemen, we are still keen to have questions from the audience arising from what has been, I think, an extremely interesting panel discussion to date.
I just wanted to add that, you know, we're, most of us, well, certainly Brick Court Chambers, this is a Brick Court Chambers event, we're lawyers and we're speaking in a very legal context, in a legal way. What I have been trying to do over the last 4 years in a very small, modest and piecemeal sort of way is to promote administrative cooperation in the regulatory process and the enforcement process along the lines that we have used here in Europe. I said that the role of national courts and the European courts in the development of European integration over the last 70 years has been absolutely fundamental. But I'm afraid, and you know, it's interesting, one of the reasons why I went to Swaziland to have 2 days with the 12 judges of the COMESA court was because they had a case pending between Egypt and Mauritius. And they wanted to have a sort of seminar, you know, a brainstorming session, and we had that for 2 days, basically on the free movement of goods and non-tariff barriers and all the rest of it. But that's very rare, I think, you know. And I'm trying to provoke José a bit here. I wish that Europe, I mean the European Union, complex as it is, and the EAS is a new institution, only 5 years old and so on, but our combined resources would be absolutely phenomenal if deployed in the right way. And I think we're spread too thin. You know, we focus in terms of exchanges between lawyers and administrators and so on, not on Africa, but on other places. States which are applying to become members of the EU. But Africa is an absolutely top priority for Europe, and the rule and the role of law is absolutely vital. And we need political attention to focus not on doling out 30 billion development aid only, but actually sending people who deal with non-tariff barriers, how to resolve your peer review systems, soft law techniques, how we've made progress in a quiet way to cooperate, build friendships, build trust, build confidence, build respect, based on success stories, because that's what inspires people. You know, the fact you've actually solved issues in a particular way. So too much emphasis on lawyers, courts and appeals and all that stuff, that's fine. But if I think of myself, not in London, in the legal London here in the Lincoln's Inn, but if I think of myself in Lusaka or Ouagadougou or Arusha at the moment, yes, courts are important and law is important, but it's much more administrative cooperation we need to focus on.
Yeah, we've got 2 questions at least in the audience. Sorry, could we have the roving mic? We've got the lady in the middle there. Thank you very much. Could say your name. And,
Hi, I'm Amy Clark. I'm an underwriter for an insurance company in the city. A question a little bit more about the role of international finance institutions. So we've talked a lot about Europe. A previous job at the World Bank in the International Finance Corporation. Arguably some of the most vanguard projects in some of the countries that the private sector isn't willing to touch. Angola, Rwanda come to mind, being there for a good few years, the World Bank, IFC. What do you see as a role, this is perhaps a question to Alastair in particular, a role for not institutions that don't sit in Europe, particularly the World Bank, going forward in sub-Saharan Africa in particular?
I think I'm thinking now of the African Development Bank, for example, and also to a certain extent European financial institutions. I think the role is extremely important, because what you do there is you combine, you know, the provision of finance with the opportunity practically to ensure that all the principles that we've discussed here in the last 2.5 hours are actually implemented in practice in a very cooperative sort of way. It's exactly what I've been talking about, really. So does that partially answer?
It does. I mean, they're also arguably the most sustainable projects that have been put in place by the World Bank over the years. But I think the fear is, or that there is some debate around whether the continued involvement of these, of the World Bank or the African Development Bank pushes out the private sector.
I see.
And you know, in a way, because of the leverage that the World Bank has, it's not necessarily a straight rule of law question, but it's you rarely get a default if it's a World Bank project, because of the amount of time it's taken to put into place and the leverage it has, and they almost work as their own arbitrators in the situation,
Yeah.
which I often find a little bit confusing in terms of the place of the normal rule of law for these projects.
thank you very much. I think we have a question down the front here. Again, if you could say your name and your organisation.
Hi, thank you very much. Adam Smith-Anthony from Omnia Strategy. Just to follow up on one of Alastair's last points, and it's just a brief question. Interested to hear what you're saying about the priority of sending technical assistance, legal assistance, capacity builders to African markets to help with these kind of things. Just wondered what your thought is, and then also what the thoughts you think might be of those that you're speaking to in Africa, policymakers and the like, on whether that assistance should come out of, or the cost should be borne by aid and development budgets in Western countries, or whether that should be on top and above those kind of budgets and coming out of Foreign Office or DFID style budgets. So there's a discussion recently on whether peacemakers should be, the cost of peacemaking should come from development aid budgets, which it hadn't been previously as military. Just a thought on whether that's all aid or whether it should be on top.
Gosh, this is a bit of a tricky one, really, and I'll, you know, Chatham House and all the rest of it. I mean, I think a lot of development aid money would be far better spent immediately on this kind of technical assistance. And one of the reasons for that is the extreme difficulty these days of dispensing classical development aid. Again, José is better placed to talk about this, but if I just talk about it from a Commission point of view, the European Commission, which is probably the biggest aid donor in the world, I imagine, has delegated decision-making authority on individual projects, the financing, to the heads of delegation in the recipient states. And the problem with that is that people now are so afraid of review by the European Parliament, the Court of Auditors, that the money simply doesn't get dispensed, you know. So you'd be far better off spending a lot of that on taking people and building the kind of camaraderie, trust and, you know, cooperation, friendship even, where people are willingly going to receive the kind of technical expertise that I'm talking about. That still wouldn't solve, I'm thinking again of a meeting in Lusaka last year, it wouldn't solve this deep-seated unwillingness in secretariats like COMESA to take on, if I can put that in inverted commas, the member states. That is I don't know how you overcome that, because they're brilliant people working in these secretariats, but something happened in Brussels in 1950, which the supranational concept, you know, which gave legitimacy to international civil servants to question you know, the member states. And that's a bridge that has to be crossed in Africa still.
Thank you, Alastair. One very brief comment, if I may, from José, who's come all the way from Brussels.
It's a good argument. No, just to clarify in your question, there is a legal basis for European head to development, which is the Cotonou Agreement. And the Cotonou Agreement has rules that establish that development programs are the consequence of a consensus between the donor and the recipient. So when the sectors are chosen in the national and the regional indicative programs, which is the way that the money is channeled to countries and regions, this is done in cooperation and in agreement with the local authorities. There's a national coordinator, usually the Minister of Finance, who explains what the Africans want, the Africans, the Caribbean, and the Pacific want explicitly as sectors. So, just to add something, that 21 or 22 countries in sub-Saharan Africa have chosen governance as one of the key sectors, which means that some of the things like technical expertise being sent, seminars, workshops, where we try to do something that is fundamental for all this project to become a reality, which is capacity building. Without the necessary capacity on the African side, none of this can progress. And so we are focused precisely on this particular arrangement. So it's not impossible to use on the country development money for this. We can even use development money for peace and security issues, like the case of AMISOM that I explained before as an example. This also comes from the EDF. So development, stability are now seen in a very inclusive way in order that we precisely prevent to have this kind of ideas of just being on one side or the other. This already been won in Brussels at 100%? Not necessarily. There are always some resistance and people that still follow the old regime. Thank you.
Thank you very much indeed, José. I think the takeaway point from this, and I'm going to be about 10 seconds because otherwise Harry will cut me off, is that the rule and role of law, as Alastair said, is critically important. The EU, as José has said, is here to help. Much of Africa can benefit, as Alastair said, from the internal market, but it may well seek to do it its own way. The way in which public interest has been seen in South African merger cases, critically important. And as Robert has made absolutely clear, due process is critical. The question is how much and where is Africa going to go on that? That's for another occasion. But ladies and gentlemen, thank you for listening. And if you could thank your panelists, who I've been delighted to chair.